G'day everyone and welcome to video 3.2.8 for the Legal Studies guide. Today we are covering off judicial powers of case management, but first of all our quote is from Sophia Amoruso. It says, "Abandon anything about your life and habits that might be holding you back. Learn to create your own opportunities." And this is a big thing with year 12 is one, thinking about, okay, what habits are you creating, what things are you doing that are helping you succeed, so what's propelling you forward, and we talk about goal setting and study habits and that sort of thing, but also starting to contemplate what sort of things are holding you back, and trying to actually get rid of those things to create further opportunities. These are things like maybe it's your sleep habits, maybe it's what you do on the weekend, maybe it's procrastination, but learning to or figuring out ways to overcome those things that are holding you back. As I said, we're 3.2.8 today, which is judicial powers of case management. Okay, so this is a new dot point and it's building off that last dot point on the key responsibilities in a civil trial, and it's what powers the judge has, including the power to order mediation and give directions. So we'll talk through that in a moment. It comes under the same skill of discussing the responsibilities of key personnel. And our essential question that we're answering is, what case management powers does a judge have? So as we know from that last set of slides and from back in criminal law as well, the judge is that impartial third party. You enforce rules of evidence and procedure if you're a judge. Decide the questions of law, decide on a remedy if there's no jury, give directions to the jury if there is one, and basically, as I said in that last slide, you possess significant case management powers. Now, why I think that they have introduced this dot point into the new study design is because of this comment from the examiner's report in 2016. And this from 2016 says, there still remains a misconception that judges in the adversary system are passive and have no involvement in the case. Okay? So what was happening was this overarching view of the impartiality of the judge, so the judge doesn't take sides, had turned itself into this misconception with kids that was coming through in their answers, that judges were passive, that judges wouldn't involve themselves because they wanted to remain impartial, when in fact students are urged to consider the significant powers of case management that judges have. So trying to actually change the view that judges are these passive, impartial men or women who sit at the front of the courtroom and don't really involve themselves, and to change it into this idea that judges do control the courtroom, judges do have a lot of power, and judges can do certain things and force parties to do certain things. So they add in this new dot point. What case management powers does the judge have? And this initial starting point to look for these things is in the Civil Procedure Act, which has basically all the information about anything civil that you need to know. Some specific examples of what judges can do. In the Supreme Court, judges will be allocated a case once the writ's filed. So once the writ's filed, the court will look at it and be like, all right, I will allocate that to this judge. And that judge will immediately meet with the parties, like trying to meet within a week to give first directions and to start trying to work out exactly what the claims being made are. Any further directions hearings that they have, so any future directions hearings, the judge will also run, as well as any case management conferences, which we know use conciliatory methods, so where the judge might actually suggest ways that the parties could resolve the dispute. They don't have to take those suggestions, but they might suggest it anyway. At directions hearings, judges may give orders to the party, okay, court orders that the parties must follow. And really, really broadly, and I think this is our absolute key point when it comes down to case management powers of a judge, is a judge may make any order that they believe will help lead to the just, okay, so thinking here, fair, to the just, prompt, and economical resolution of a dispute. And we know prompt and economical both are going to feed into access, and that'll come up in our last slide, obviously. but judges may make any order that they believe will help lead to the just, prompt, and economical resolution of a dispute. So significant powers. What might those orders be? Well, mediation for starters, and that's explicitly listed in the study design, that the judge may order mediation, so that's one you definitely must know. And we know that mediation will be ordered in the majority of Supreme Court cases, with, I think, the stats somewhere around an 80 to 85% success rate. So trying to avoid a trial and a lengthy trial. So judges might order parties to attend mediation, so they have to go. Judges might even act as the mediator in those cases, so run mediation through the courts. Judges at these directions hearings might rule on the admissibility of evidence. They might tell some parties that they can't use some evidence in the trial. They're not allowed to bring that forward. They can dispose of some issues. So, for example, in the Falls case, the Falls Festival case, we looked at the writ, or you can look at the writ online, and there's about 8 or 9 different claims around how the Falls Festival breached their duty of care. At a directions hearing, in that case, the judge might look at it and go, you know what, claim 4, 6, and 7 are unreasonable, and we're going to dispose of those. You're not going to argue those in court because it's not worth it. So the judge might actually dispose of some issues and remove some factors from the case. A key one is fixing timetables. So when will witnesses be in? How long will the case take to hear? That sort of thing. And they might even limit the number of witnesses at trial. So this is important if a party thinks that they'll maybe try and elongate the dispute by calling extra witnesses, a little bit of, causing a bit more stress financially perhaps, or emotionally to the other party. The judge can actually limit the number of witnesses and say, no, you can't do that. You need to only have this many. So if we look at that list, we can really straight away see that judges aren't just these passive, sit back, don't really do anything lads or ladies. They can basically get the parties to do anything they want in order to try and resolve that dispute. And the whole purpose of this, as we know, is trying to avoid ending up at trial, trying to resolve the dispute as quickly as possible and in a way that is as effective as possible. As I said at the top, this fits into our skill on discussing the responsibilities of key personnel in a civil trial. So basically this dot point feeds into that responsibilities of the judge and builds your understanding there. For example, the sample exam that's been released by VCA has a question that requires you to evaluate the role of the judge and jury in relation to fairness and equality. So you would be able to feed into that question some of your case management powers of the judge. But we also might get a question such as this. Identify the case management powers that a judge has, including a reference to a specific order that they can make. And I think that they could include, I'll go back one. I think that they could include this part because they do tell you that you need to know that a judge can order mediation. So they can court order mediation. That's specifically referenced and something that they could ask you about. An answer here would just be as simple as the judge in a civil dispute holds significant case management powers. Namely, the judge can make any order that they believe will help lead to the just, prompt, and economical resolution of the dispute. So the fair, prompt, and economical resolution. This may include, so ticking off that including a reference, this may include ordering the parties to undergo compulsory mediation. So that would be 1 mark there and 1 mark there for a 2 out of 2. Evaluating the ability of the civil justice system to achieve the principles of justice. Well, let's give the usual time for you to try and figure that out yourself. And in 3, 2, 1, let's have a look. So really building off those key responsibility stuff again, the judge is the legal expert. They are trying to make a just decision, therefore it is fair. However, you could argue that case management powers resting with one individual could increase the risk of bias. And also looking for or trying to prioritise a speedy resolution, perhaps through mediation, might lead to a resolution that's not fair if a party compromises too much. Both parties are going to go to the same hearings, follow the same direction, so it's equal. But there is no precedent present in any pretrial decisions that are made, meaning that disputes might not actually end up being resolved the same. So some disputes might be resolved differently depending on the judge in charge. Finally, it is, as I said, quite a fair bit of this is about access. You're identifying your issues at the earliest possible point. You might be ordered into mediation. It's more cost effective. We're trying to make the economical and prompt resolution. So key things there, economical and prompt. But if mediation doesn't work, it's going to increase delays, which does limit access. Applying to hypothetical or actual scenarios, just building our understanding through some further links, I suppose. All I'd say is direct you to the relevant section of the Civil Procedure Act, and I can post that link below this video, or you can type that one in. Ultimately, do we understand or can we list off some orders that a judge can make? Do we understand what case management powers they have? Hopefully we do. Hopefully you can answer this question at the end of this. This has been the Legal Studies Guide. Feedback below or subscribe to YouTube.